an attorney. I've been licensed to practice law in the state of Michigan since 1995. One of my areas of specialty is in consumer law, which is an area to address overreaches or abuses by businesses that prey upon or take advantage of consumers.
So we're here today to talk to you about arbitration, something that you've dealt with in the past. Maybe you can explain to the consumers, what's arbitration to begin with?
Originally, it's a quasi-judicial form in which cases or controversies are settled, meaning it's not subject to a court proceeding, which otherwise would be open to the public. It's conducted privately. The arbitrators are typically either former judges or attorneys that are familiar with the legal system, but it's all done in a private proceeding outside the eyes and ears of anyone else. The concept that was originally envisioned with arbitration was in response to the time lag and difficulty of actually taking a case to a jury trial. Here in Michigan, most jury trial cases could take a year and a half from the date of the filing until the date you get your court date and have your chance to have your day in court. The idea of arbitration was that in order to relieve the courts from their docket load, that certain cases could voluntarily or by contract be submitted to arbitration. And the idea being that it would be a simpler, faster, easier way to get finality in terms of the resolution of a dispute.
So the disputes that we're talking about is consumers who have a complaint against a major corporation, and the consumer wants to resolve that issue, can't usually afford an attorney or go to district court, but they have the option to go to arbitration. Is that beneficial to the consumer to go to arbitration as opposed to maybe filing a complaint in district court? What's going to be more advantageous for the consumer?
It depends. Arbitration has to be either done voluntarily, in which both parties agree, or it can be done by contract, in which one party or both parties in advance of a dispute indicate that any dispute arising out of the relationship between the two parties would be resolved via arbitration. That ties in with perhaps one of the potential overuses or abuses of arbitration clauses, which is sometimes it's forced upon you rather than you voluntarily agreeing to it.
So a consumer can ask to go to court, and the corporation will say, we have an arbitration agreement, we don't have to go to court. We can settle this out of court, essentially, is what they're saying. And by doing so, does that work in favor of the consumer, or does it work in favor of the corporation?
It depends who's drafting the arbitration provisions. So originally, federally speaking, there was a 1933, I believe, act called the Federal Arbitration Act. And the original concept was balancing the parties' ability to a right to a trial versus the right of the parties to contract for a remedy. And the original Arbitration Act, federally speaking, recognized that the parties can contract for an arbitration proceeding and thereby waive their right to a jury trial. Most states have similar provisions. Michigan has an Arbitration Act as well. And originally the idea was that sophisticated parties, like any other contract provision, could understand and appreciate their rights, and by contract waive certain rights if they felt it was in their best interest or to their benefit. So maybe as originally intended, it may have been a good idea. The difficulty is that the way that arbitration clauses have been enforced over the past 70, 100 years is that you can have a situation where, for instance, if you have a credit card and you sign up with your bank, embedded in the fine print on the contract or terms and conditions is a waiver of a right to jury trial, mandating that you have to take any dispute with your bank or credit card company to arbitration. Oftentimes when you sign up for those services, most customers aren't even aware of what's in the fine print, aren't even aware of the arbitration provision, and it can be what I call a unilateral agreement, meaning that the bank or credit card company can say, just by you agreeing to accept this credit card or bank account, you're agreeing to this arbitration provision, even if you never signed it. That tends to have overreach in the sense that, is it really fairly, fully bargained for and exchanged? Unfortunately, most of the judicial decisions or legal decisions have interpreted those arbitration provisions to apply even when somebody doesn't formally sign a contract. So it can be forced on you without your really understanding of what's happening. The significance of that is that they can also, in a sense, construct the way the arbitration is going to happen. For instance, it may be that the contract specifies that it was a panel of arbitrators through an industry association. And oftentimes the industry association arbitrations are employed by the banks or other service providers that you're suing. So the fees and expenses and allegiances of the arbitrators are in advance perhaps slated in favor of the industry, not in favor of the consumer.
So the consumer is at a disadvantage in most cases when he goes to arbitration because the corporations can contractually and arbitrationally rule whatever they want to rule, even though they may have a judge or former judge or attorney or someone else that is acting as the arbitrator, making decisions for them. And they're making that decision based on what? Are they based on the facts? Or are they based on the money that's involved? Or is it based on how they want to just look at that and accept the payment that the arbitrators get for hearing that particular argument?
There are a number of different types of arbitration forums. There are private companies that parties agree to in advance that have their own rules. There are industry associations that have their own rules. And the point being is that oftentimes industries that craft their arbitration provisions can define the playing field in advance of a dispute. And they can define the playing field in advance of a dispute such that it's home field advantage.
So as we look at arbitration agreements that are applied to a lot of purchases that a consumer might make, whether it be a refrigerator, a telephone, or a TV, that arbitration agreement could be written in such volume of pages that are in 8-point type that it would take not only a person that understood what that whole document meant, it would be difficult for them to read 28 pages before they signed or agreed to make the purchase. So that's where the disadvantage comes in. Is that right?
That's one of the disadvantages. They can also put limitations. For instance, in most consumer cases that are not subject to arbitration provisions, there's also the potential for a class action, meaning that if you have a claim that might be, albeit in and of itself, not significant from a damage perspective, but it affects a whole swath of other similarly situated claimants, without arbitration, you could file a lawsuit and pursue a class action on behalf of all other victims who experience the same harm. Knowing that, many industries or companies can craft arbitration provisions that limit your ability in arbitration to pursue a class action. That helps them because then they're dealing with a case on an individual basis, and if the damage potential of an individual case is nominal, they're not that worried about the economic impact of that particular case because they know in advance that you can't aggregate your claim with all other similarly situated victims in something like a class action lawsuit.
We were talking about arbitration agreements and how they don't fare well to the consumer.
perhaps slated in favor of the industry, not in favor of the consumer.
That most everything now is that way, and it seems like everybody's jumping on the bandwagon. It seems more and more prevalent today. With all the agreements being updated, I think that legislature has to be changed in order for you to not have to agree with everything that that arbitration agreement says. I think corporations have to be responsible. I think arbitration needs to be revamped. It has to be looked at and said, you can't place all the responsibility on the consumer.